Okay, we're on the record in the Gibson-Martin case, 0853617. That is on this afternoon for entry of the final orders. In regards to the first order the court's going to enter, it's called the Residential Schedule Final Order. Do either parties have any questions about that order? You first, Ms. Martin. Any questions?
I think I understand the order, Your Honor.
Mr. Gibson, any questions?
Yeah, from this order, I basically don't get to see my son except for under the most extreme circumstances.
As set forth in the order, Mr. Gibson. Anything further regarding the residential schedule? I'm signing it at this time. Next order is the judgment and order for petition establishment of parentage. Any questions regarding that order? Ms. Martin?
No, Your Honor.
Mr. Gibson?
Nope.
Was there an acknowledgement of paternity when Ezekiel was born?
Oh, yes.
So was there a document filed at the hospital at that time?
He did not take care of that.
What was the acknowledgement?
Well, I never denied from conception that it
So you're just saying orally?
he didn't get the paperwork done. Because we weren't married, I understood there was paperwork that he had to fill out, and it didn't happen.
On page 2, 3.2 of 6, page 2, paragraph 3.2, I indicated that Wardell Donald Gibson is the parent of the child, and any acknowledged father or adjudicated parent named in the proceeding is not the parent. So this states that Mr. Gibson is the father and that there are no other acknowledged or adjudicated parents. Any questions regarding that from either one of you?
No, Your Honor. Except where do we sign it?
Mr. Gibson, any questions?
Nope.
On page 3 of 6, on paragraph 3.5, I checked the box because Ms. Martin was to determine the judgment owing for back support. It's my understanding she has not had an opportunity to do so yet. Is that correct?
That's correct.
So
I thought we were doing that January 5th, and I just got this packet yesterday.
I'm not checking that box in at this time. I'm checking the box that says unpaid child support due under a court or administrative order is preserved for collection, is not merged in or extinguished by this order.
Where's that?
Further down that paragraph, it's box number 4.
We still have a hearing on January 5th?
If you want to cite it in for entry of your judgment at that time, you can do so.
Well, I'm confused because he was told to bring $10,000 on the 5th, and I was going to calculate the child support because we agreed it was at least $10,000. Are we still there, or?
I have a question regarding that.
It's on the schedule.
Okay, then I get it.
Mr. Gibson, question?
My question is in regards to the child support being paid to the state of Oregon.
Yes, sir.
Will I be allowed to do that with the $10,000, pay it to the state of Oregon under child support so I'll get credit for it? For I have not gotten credit for the $4,500 I paid thus far.
Did you take, Oregon, a copy of the order that says you paid it?
I intend to do so that I can get credit for it. And it looks like I'll be able to do that on or before the 5th of January and be with the state of Oregon and get a statement or a receipt from them that it's been paid to the state of Oregon.
All payments go through this court. All payments go through this court. Would you hand him a copy of this order, please? Hand that to Mr. Gibson. You need to get that certified by the clerk's office up at the courthouse. That is a court order receipt of payment of the $4,500 that you need to take to the state of Oregon so that they credit your account.
Thank you, Your Honor.
Okay, get it certified, take it up there, and they should take care of it for you. All right, then I'm signing the judgment at this time.
Your Honor, as you're signing that, at 3.5, it says judgment back support payments will be made to Washington State Support Registry. So you have preempted that by bringing it to the court, correct?
Well, that's a provision that's included in the order of child support, whether she elects to go that way or not. And I don't know what Ms. Martin's preference is going to be on the final order of child support that she has not prepared.
But the $10,000 is a cashier's check he's bringing on the 5th as well.
That was my order from the previous hearing, that you indicated that you would bring the $10,000 in. Is that correct, Mr. Gibson?
Yes, but since that time, it's been brought to my attention that, and I've heard your ruling, that the $10,000 should go to the State of Oregon Child Support Division, as she's receiving, I understand, well, that's her situation.
Have I clarified that for you, that the
Yes, you have.
$10,000 comes
bring
through
it.
this court, so that we have it receipted in this file,
In my name, correct?
in your name, correct? All right, then sign that document. Next document is called the Findings of Fact and Conclusions of Law. Any questions, Ms. Martin?
Is there a time on when we're supposed to get a hold of this supervisor? I mean, it's
Did each of you-
Christmas. I'm willing to contact her as soon as possible, but
I sent each of you a copy from her webpage with her name and phone number on it.
okay.
You have not gotten in touch with her, Ms. Martin?
I just received this stuff yesterday because I had to go pick up the mail, so I'm trying to get up to speed on what I can call her today if that's doable.
Mr. Gibson, did you call her?
No, I received this recently, too, in the mail, and I definitely intend to. If I ever want to see my child again, I guess I have no choice. I'll make that call today.
Your mail is going to the Alice Street address that you gave the court, Ms. Martin.
Yes, but I haven't been there. The last 3 days I was in Eugene, so I didn't pick up this mail until yesterday.
And your mail is going to the 47th Avenue, correct, Mr. Martin Gibson in Portland?
Yes, Your Honor.
You indicated that you were not purchasing another house at this time? Is that what you said at the last hearing?
That I was not?
That the transaction that you were entering into to purchase another house, you weren't following through with it at that time?
What's happened, Your Honor, is I own another property in the state of Oregon, and we've taken out some of the equity out of that house. It's now with the title company and so forth, and I'm hopefully that we'll have that ready to go for her by then. The house on 47th Avenue, that's another situation that we have entered into agreement to purchase that house as well.
So that was the one that you were in negotiations with to try to buy?
That's correct.
Any further mail from the court will go to those two respective.
We'll go not to the Harold Street address, to the 47th Avenue address.
47th Avenue and Alice Street. page 4 of 5 of that document, paragraph 2.6, the child support provision. It says the order of child support signed by the court on this date, putting reserved for further hearing, because I'm not entering it today.
I have a question on that, Your Honor.
Yes?
I believe my income is going to change between now and January 5th. Do you want me to stick to the numbers that are outlined in this document or file a fresh financial of what my new life is going to look like?
The order is based upon the evidence presented during the trial, so that's what the
I have this.
final papers must say.
Okay.
And that reminds me.
I have the same question regarding that. You've got my income at $3,700 a month. It's nowhere near that, and I will.
You're 61 years of age, Mr. Gibson,
Yes, I am.
and you're 54.
4.
Thank you. I set forth the reasons as to how the support obligation was calculated based upon the Washington State child support laws. Based upon the parent's age and gender. There's no history of employment. Again, there was insufficient evidence at time of trial for me to make a finding as to current income, historical rate of income, or minimum wage income. So I set it based upon the respective ages. And that's what the child support guidelines call for. Anything further on the document titled Findings?
Yes, Your Honor. On page 5, you've got in here a lot of statements that are based upon what she says with no corroborating information, no evidence, nothing. On page 5 at the top, he wanted to kill me, also kicked and punched her numerous times and said I didn't like God. Her own testimony says that I've never ever touched her. I have no idea where this comes from. Wasn't in any testimony, and it's just a lie. Yet you've got it as basic of fact. I'm just questioning where that came from. There's no testimony to that effect.
Okay. So noted for the record. Anything else?
Again, on the bottom of page 4, she, with no corroboration anywhere, has the respondent picks up the child from his father's after visitation. The child was very abusive. We were calling her a bitch, maniac, and loser. He wanted to kill me also, and all that. This just never happened. And so I don't understand how you can have it as a basis of finding a fact when there is no facts to that fact.
Okay. Again, the court has heard the testimony and the evidence presented, and those are the findings that I made from that testimony and evidence. Next, Mr. Gibson.
Yeah, there's on page 7, there's another statement that you call fact about one of my witnesses as the respondent and her friend Patrick McEachran were in the court lobby, that the petitioner's witnesses made comments to her. Nobody spoke to her at all. As a matter of fact, it was Mr. McEachran that confronted my witness, and that's how that happened. Nobody said anything to Ms. Martin. Nobody called her a bitch. This just didn't happen, and yet you have it in here as a statement of fact.
Okay, again, based upon my review of the record, these are my findings. Next matter.
On page 8, there is just a basic light weight given to Mr. Vedder's opinions, and the court appointed through Mr. Vedder Dr. Kirk Johnson. But it seems that because she did not have a manic or psychotic episode in front of Mr. Johnson, that the court then basically says it doesn't really matter, not taking into consideration Dr. Johnson's years and years of education and years of practice. It's as if that matters not, simply because she didn't blow up in front of him. I find that to be bizarre.
Again, the court considered the testimony of Mr. Vedder and Dr. Johnson in making its decision.
On page 8, it talks about petitioner providing gifts on birthdays and Christmas, but has failed to financially support the child. It's as if I haven't supported him at all. That's just not true. The court is finding on page 9 that the child has a significant relationship with the mother's friend, Mr. McEachran, who you have as one of the persons that can deliver the child to the mediator person 4 times if he's chose to do so. This is a person who accusations have been made of abuse and sexual abuse. This is a person that we had an altercation with in her home, of which I was charged with 2 felony and a misdemeanor, and I was acquitted of. And then to have this person who just says, I haven't sexually assaulted, but he sat on my lap naked and I sprayed him with water with 2 naked little boys. I would remind the judge that in the case at Penn State University, it went on for 15 years before the light of day was shining on it. These people do not do what they do in front of other people. And for you to then just actually allow this person that I know, you may not know, but I know he has inappropriate behavior with my son, to have this man be the one to have to deliver the son to this in front of my face is like putting salt in my wounds. And it's, I guess what you're trying to do is set up a situation where we could have another altercation.
No, that's not the intent to.
And what is the intent?
Deliver Ezekiel to your face, sir. The intent is to transport the child to the office, and
but why him?
Arrangements would be made with the supervisor, so that there's no contact such as that between you and any other third parties.
And then the other situation is, why hasn't the child been examined? I mean, how can you make this decision about there's been no abuse? Has anybody talked to the child? Has an agency like CARES investigating this? I mean, how can you make this ruling without anybody? You even say in here that the child is, and we both agree, in the top 1% in the country in intelligence, but nobody's bothered to ask him. And with independent people like a care situation, who know how to ask children questions who have been abused. Why hasn't that been done?
The matter was referred to the Oregon CPS by friends of yours, and the testimony from Ms. Fons, was it, is that they took no action.
Well, after his testimony, they reopened an investigation, and that investigation is not...
Based upon that evidence and testimony, Mr. Gibson, the court's not making any finding of molestation here. I'm not making a finding that the child was molested. There's insufficient evidence to do so. Insufficient evidence to establish that this child was molested.
Only because you didn't search for the evidence, Your Honor.
Searching, Mr. Gibson, it's your responsibility to put the case on for trial, not this court's. You present the evidence, I weigh it as presented, and I make my decision from that.
On page 9, you talk about a domestic violence as defined as physical harm, bodily injury, assault of infliction, or of fear of imminent physical harm. Ms. Martin testified, not only in this trial, but in the trial in Hillsborough, that I have never, ever put my hands on her. Terry Vedder said the same thing. Where is the testimony that says that I have done bodily harm to her anywhere, anytime, where? And where is the evidence of this? She says that I pulled her off the bed by the arm. You have this as a statement of fact, yet she testified under oath that I've never put my hands on her. Where did this come from, that it's a statement of fact?
Based upon the testimony during the trial, the court makes that finding.
Testimony by whom?
By Ms. Martin.
Her testimony was that I never touched her, never put my hands on her.
She also testified during this 3.5-day trial as to other incidents of abuse.
She also testified to being a very dangerous woman and a third-degree black belt and training up some 30 other people to be black belts. She also testified that she had a organization, a company, a business that she had called Save that taught women how to defend themselves against 6'3", 260-pound tall black men.
And the court heard all of that testimony and evidence and weighed it in making my decision.
Wow.
Anything further, sir?
I would like to know why is it that you have testimony in this so-called factual information that has none of my witnesses, the person that testified about her putting pornographic information, gluing it into my Bible. I don't see that. Alicia Rainier and Arliss Phones, their testimony. You basically knocked Dr. Kirk Johnson's out and Terry Vedder's out. Yet without any corroboration whatsoever, you have as fact that from the testimony of Louise Broussard, that as Stacy Cohen, even in the fact that she says I knocked this door off the hinge and then somehow walked up under the hinge, and then somehow or another she decided to take me out for my birthday at a place where wine and beer is being served, and then on top of that wanted me to be involved in her business model. It's
again,
just,
Mr. Gibson, the court considered all the testimony of all the witnesses and weighed all that evidence in making its decision.
really.
Next issue, please.
Responded on page 10 was in fear of imminent physical harm when she, the petitioner, got into arguments. And I guess the bottom line here, sir, is because I'm a tall black man. No, I'm serious. because I'm a tall 6'3", you say 260 pounds. I've never weighed 260 pounds. I weigh about 225, 230. Miss Patrick McEachran is 6'5" and outweighs me, but because I'm a tall black man, that it's okay for everybody to be afraid of me. And is that your ruling?
No, it is not, Mr. Gibson.
Well, it says here that I'm tall, 6'3", 260 pounds, and what I gathered from that is because of that, Miss Louise Broussard is intimidated me. She's intimidated. Everybody's intimidated because what? I'm tall and black. I don't get it.
No, sir. And I think that's an unfair characterization.
Not at all, sir.
Mr. Gibson, I think that's an unfair manner in which you're characterizing this. At no time during this hearing did race ever come into this case, other than the fact your son is biracial. This court has always treated you with courtesy and professionalism the entire time that I've known you for the last 3 years. Except for this ruling. In 20-some hearings. So at no time did this court ever make any comments like that. At no time whatsoever.
Well, then, if that's the case, then, and I'll take your word for that, although I disagree with you, then why is it then that Mr. McEachran, where testimony was given that he had assaulted Miss Martin a number of times, she wrote about it in her book that you would not allow into evidence, that he attacked her, had to run into different farmhouses and other houses, attacked her in a pickup truck, grabbed her by her neck, almost broke her neck, caused her to run into a tree. None of these things have ever happened to me. He's 6'5" and 250 pounds.
I don't recall any testimony about Mr. McEachran's height or weight.
Oh, you didn't have to. You saw him in the courtroom.
He's 6'3".
Findings I make were based upon testimony.
So I'm intimidated because I'm 6'3" and 260, which I'm not, and 230. He's, according to her testimony, 6'3" and the same weight. But what's the difference? He's a white man, I'm a black man. I don't get it. What's the difference?
The difference, sir, is that Mr. McEachran's incident with Miss Martin approximately 17 years ago, the court did not place as much weight.
And the incidents that you're talking about here happened before Ezekiel, before she was even pregnant with Ezekiel.
I've given you for my decision, so if you want to continue in this way, this hearing will conclude. Because when I want to answer your questions, you don't want me to answer them. You keep interrupting again. Anything further, Mr. Gibson?
I'd just like to reiterate on page 10, the bottom paragraph, the petitioner also argues that the mother is unfit because of her alleged mental health issues. This issue was discussed above, and even though Dr. Johnson diagnosed the respondent as hypomanic, he did not witness any psychotic levels, nor did the respondent report any. Again, there was insufficient proof that mother's diagnosis affected the child's well-being in any way, except for when she was on the stand and psychotically accused me of attacking her 20 or 30 or 40 or 50 times. Yet there was no police reports of that. She never reported it to the police. And so I've been marked all over the YouTube, all over the world, as this violent domestic violence with absolutely no corroboration whatsoever. No police reports, but you have it as a statement of fact.
Anything further, sir?
It won't do any good for me to go any further, apparently.
All right, I sign the orders in. That concludes today's hearing.
Thank you.
Your Honor, I'd like to go on the record as noting that this decision, this egregious decision, will be appealed.
Linda, not Linda, I'm sorry. What's the procedure for getting a copy of the signed order?
When do I get my paperwork and stuff that I have in as evidence release?